Hi everyone, I hope you all are doing well. This video today is about patent filing for R&D teams, how to document, how to search, and how to start preparing your first application. Before we proceed further, it is important to know why you want to file for a patent. Patents may be good for protection of your innovations and inventions. Patents help in branding of the organization. When you have patents in your name, you can always label your products and advertise that patent is applied for or patent is granted for a particular product. And once you have a patent and you have licensed your patent, it could serve as a source of revenue for the organization. So that could be one another reason for filing a patent application. For the team, it may be incentive and inspiration because when the patent gets filed, it is the moment that teams feel very good about filing a patent, and they can put that in on their resume. And once patent starts making money, there could be revenue share with the team as well. And once you file your first patent, quality of research also improves because after filing your first patent, you get to know a lot about how the novelty search is done, what is expected out of patent application. So when the examiner raises objections, you get to know how to address the issues related to novelty, non-obviousness. So slowly and steadily, when the organizations they start filing for patents, the quality of in-house research also improves, and you obviously implement right systems and processes to safeguard your innovation in terms of IP policy, employment agreement, coordination with the attorneys, non-disclosure forms. Lots of things they get streamlined when the organizations they file for patents. And also, most important thing is that your thought process gets aligned with market needs, and that's how the quality of your research automatically improves when you start filing for patents. Now, what exactly is a patent? So, the word patent means to disclose or to lay open. So, that means when we decide to file for a patent, we have to disclose details about the invention to the government of India if you are filing an Indian patent. And that's where best mode requirement or disclosure of invention becomes a very important part of the entire process of patent filing. And after a patent is granted, you get certain set of rights from government of India for a specific period of time, and this time is 20 years from the date of filing. So if you file for a patent today, exactly after expiry of 20 years, the patent gets expired. So this time of the patent, the term of patent is calculated not from the date of grant, but from the date of filing your patent application. And very interesting part of a patent document is that in patents there is a section called as patent claims. So claims determine what are the rights you get once patent is granted. So unlike a paper publication, you have certain set of rights granted to you in the form of patent, and that makes a patent very different and more stringent compared to a paper publication. It is very important to know that patent rights are territorial, which means that your Indian patent is valid only in India. In US, people can use it without your consent. Similarly, a US patent is valid only in the US, and in India, they don't have any rights. So, to use that patent in the territory of India, you don't need to seek a permission from a US patent owner, because if there is no Indian patent, you are free to use that particular Indian patent. This sentence of mine should not be taken as a legal advice. This is just a very generic statement. But if you are going to use any patent which is not granted in India, you should always seek legal assistance, because patent infringement can take you to a very different direction. There are three things which one invention has to have in order to get a patent granted. The first requirement is that invention should have novelty in it. So when we say novelty, it means that there should not be any documentation about the invention in a public domain. So you can check the patents, existing patents and paper publications to ensure novelty of the invention. There are some databases also where you can search and find out if the invention is novel or not. The second requirement is non-obviousness. Non-obviousness is one of the very important requirements to get a patent. So your invention should not be a combination of something which is already existing, but it should have some technical advancement or some economic significance. And if economic significance and technical advancement is there, you can say that your invention is non-obvious to a person skilled in the art. And third requirement to get a patent is that it should have industrial use. So once these three requirements are met, then you can always think of getting a patent. There are some free databases which you can use to assess novelty of your invention. eSpaceNet, Google Patents comes very handy. Then USPTO has its own database, and WIPO, World Intellectual Property Organization, has its own database. So these some databases are free, and you can always use them to assess novelty of your invention. So every country maintains its own database to search for patents. India has its own database. So just run a round of search in these databases to find out whether your invention is really novel and worth proceeding further with the patent or not. The process to file for a patent in your company should start with documentation of your invention. So you can always have standardized invention disclosure forms wherein there could be different fields to document details about the invention. So after documentation is done, then patent search or novelty search should be performed to assess whether invention is novel or not. And if the report is good and it is convincing, then you can always decide to file for a patent in India. So Indian filing is almost mandatory. So you have to either file in India and then go for foreign filing, or you should seek permission from Indian Patent Office and then go for foreign filing. So if you decide to file in India, then you have option of going with the provisional application or complete application, depending upon what stage your invention is in. So once you file your application in India, you secure or you get a priority date, and calculating timeline from that priority date, you can decide about foreign filing in case you want to. Foreign filing is not something which is mandatory, but in case you want to go for any foreign filing, you can always file your application outside India. There are two common ways of filing application in foreign countries. One is PCT route, and second is convention application route. So PCT route should be opted for when you are going to file your application in several countries, some 7, 8 countries if you want to file. And also, if you're not sure about how many countries you want to file right now, then PCT is a good route for you. But if you want to file only in one or two additional countries apart from India, then convention application route works very well for you. So when you are going to file PCT application, PCT should be filed within 12 months from your Indian filing. And you should make it very clear in your mind that PCT is not a granting platform. PCT does not grant you patent, but PCT only enables you file patent application in multiple countries. Whereas convention application route should be opted only if you want to file in limited number of countries, and convention application should be filed within 12 months from your date of Indian filing. So I have made a separate video on PCT versus convention application filing. So maybe you can watch it, and I will put the link in comment section below. Now coming to patent registration, actually what the process is. Uh, After you have performed a novelty search, then if you're sure about novelty of your invention and commercial utility of the invention, you can prepare to file in India in the form of either provisional application or complete application. After Indian filing, within 12 months, you can go for foreign filing in case you want to. And if you don't want to go for foreign filing, then India is also good enough, and publication of your application happens after expiry of 18 months from your date of filing your application in India. And by default, the publication time is after expiry of 18 months. But if you want to prepone your publication, there are ways to apply for early publication. And after publication, depending upon what is the workload and what is the number of your application in the queue, examination of application happens. And examination is done by the examiner in patent office. So examiners are subject matter experts. They examine your application. If they find any discrepancies, they compile all discrepancies in the form of the examination report and send it to you. And after you receive your examination report, there may be a hearing. And if examiner is convinced with your patent application, he may grant you a patent. And after patent is granted, then you have to pay renewal fee every year. Okay, and there is something called as opposition and revocation of patent. So when a patent application is filed or even after grant, if third parties they want to oppose your patent on the ground of lack of novelty, lack of industrial use, there are some given standard grounds in the statute. So they can oppose your patent application either before grant or after grant, and during the term of your patent, anytime opposition or revocation of the patent can happen. So in nutshell, you file your application in India, it gets published. After publication, it is examination. After examination, it is grant. And once the patent is granted, there is renewal fee which is to be paid. Before grant of a patent, if somebody opposes your patent application, it is called as pre-grant opposition. After grant of a patent, within 12 months from the date of grant, if any opposition happens, we call it as post-grant opposition. After patent is granted and 1 year has expired, then if somebody wants to oppose your patent, then revocation is the process one has to opt for. Uh, so this is very briefly the process of patent registration in India. So just to conclude, IP is a very valuable asset, no doubt about it. And you have to have right processes, right policies within the organization to realize full value of your asset. Sometimes, you know, what happens, invention looks very simple, but when we do patent search and all, then we find that it has very good commercial utility. So you have to assess your invention very well right in the beginning, because if you do it in the beginning, then you can always fine tune your R&D plans and processes to utilize full value of your resources. And just filing patents is not enough till the time you bring your patented products in the market and make money out of it. So commercial use, commercialization, licensing of IP, technology transfer, these all are the things that you should always have in mind when you file for a patent. And I wish you all the best. Thank you very much for watching this video today. If you have any questions, you can always reach out to us on WhatsApp or email. And you can always subscribe to this channel so that you don't miss any notification. Keep innovating, keep growing. Thank you very much. Good day.